First, today was the hearing for Sarah Boone's former lawyers. They're trying to get their money. So I'm just going to tell you what happened instead of playing it for you, because it was nothing but a picture of the judge, or footage of the judge, and you could hear the lawyers speaking. The lawyers at this hearing were Cashman, Hobson, and Bankowitz. Bankowitz said he spent 45 hours at the jail with Sarah. Remember all that? Oh, he won't have in-person visits with me and all this. 45 hours, man. That's a sentence. That's a jail sentence. 45 hours. Hobson said that Boone did not like the expert that he had for her, and he said that not only was he taxed to the limit, so was everybody in his office. He described the huge amount of work that they did and how he was always having to deal with Sarah Boone giving the law office her theory on what the law is, and them having to explain, no, it isn't, but she has her own theories, and that's how it is, right? I also want to point out that when all of these lawyers spoke, they spoke of going through the boxes of discovery and the work product of the previous lawyer. So not only was the actual discovery forwarded along, but the work already done by other lawyers was sent along with it. So Boone got the benefit of all of these lawyers. So it's not like the lawyer didn't do anything and she didn't get anything. They did the work, she benefited, and she, to this day, and throughout her trial, will be benefiting from the work that they did, and they're having to fight to get paid. In the end, after some back and forth, and JAC's argument was basically, well, them's the rules. This is how it is. Ultimately, they each got $15,000 for the work they did. I also want to mention that Bankowitz mentioned having to spend, I think it was, $400 in photocopying costs because Boone wanted things. He wasn't seeking any compensation for that or any payback for that. But $400 worth of copying, that tells you how much she was demanding and how much he did communicate with her. So we're going to move on here to the next thing. I have a meeting. Let me change this. I have a meeting at 6:30. So I want to get through all this so I can talk to you guys. And I'm not just like rushing off on you. This came out. This is the wrong document here. It's this one. Okay. The state obviously made a motion wanting the experts provided to the defense for Boone. They want those experts to have to produce reports before the trial. Looks like, according to this, that this was heard in chambers, and the judge denied this motion. So the state is going to be going in blind, having no idea what it is that the expert is possibly going to say. So that makes their job a lot harder. Next. This is the big one. This is the big news for today. Motion to suppress defendant's statement at OSCO. I think that's Orange County Sheriff's Office. And I'm going to go through this one by one and make some comments. Comes now, the defendant, by and through the undersigned attorney, blah, 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 wants the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof states as follows. I'm just checking the chat. Is the audio good for everybody? Hang on. Is that better? Okay. The defendant is charged by way of information with the single count of second-degree murder. On or about February 24th, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. The deputy spoke to the defendant and realized a death had occurred. Deputy Rodriguez, oh my gosh, I'm mangling this. I can't speak. I'm sorry. The deputy advised her superiors and secured the crime scene. You all saw that video. Sometime later, homicide detectives Chelsea Connolly and Scott Lowen arrived. These two investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the sheriff's office the next day. The defendant was ordered to remain on scene while the sheriff's office conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. And this is interesting to me. I know that it's just interesting how they put these two statements together. She stayed outside of her apartment on the property for a whole 14 hours. I don't know about that. I have questions about that. Maybe that is how it sounds, but I don't know. So, okay. She stayed outside of her apartment. Well, there was a sudden death in the house and they have to investigate, so she's going to have to stay outside. Anyway, I mean, not outside, but she can't go back in there. 6. At some point, the defendant was asked to get into a vehicle with Detective Kopsel and Detective Lowen. Once inside, Detective Kopsel recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. The defendant was advised this recorded interrogation was routine protocol, an official procedure for any death investigation. Let's take this apart. At some point, well, when? After, before she's waited the 14 hours after? What? Anyway, she was asked, not told, not ordered, not handcuffed, not restrained. I think that's important. Asked to get into the vehicle. They did an interview with her, and that was recorded. They used the word here, interrogation. And there's a whole conversation that could be had about that, but that's for maybe another day. And this partially reading her Miranda rights. Listen. She didn't partially read the rights. She partially, maybe arguably, read the card. So there are certain rights that any suspect has to be made aware of. Any citizen has to be aware of their rights, especially if they're at risk, right? Well, the fact that it's phrased in one way or another may not make a difference as long as the defendant is aware of their rights. And we talked about this before. The difference between law and policy. There's a difference between law and practice. So maybe something is always done in a certain way. Well, if it's not done in that certain way one time, the only thing that really matters is not the practice, not the policy, but whether or not the person's constitutional rights were violated. And so the defense is still on this and making it sound like, though, that, oh, she was only partially read her rights, as if she didn't understand her rights or wasn't told all of her rights. And we all heard her rights being read to her, and I don't think they missed anything significant. During the investigation, oh, wait, I want to go back. The interrogation was routine protocol. Well, yeah. And questioning all witnesses is routine protocol. It absolutely is. And recording witness statements is good practice. So this was not any kind of a lie. During the investigation, Detective Copsall asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. Do you see what they're doing here? Comply, not any other word. Comply, okay? Demands. Well, wait a minute. You just said 2 sentences above that the detective asked. And asked and demanded are 2 different things. So he's playing a game here with this language. But this judge is no idiot. Demands of the lead investigator. 8. After Detective Copsall had the defendant's phone for a period of time, she came back and told the defendant that she was taking the phone. Well, we don't know. This is a paraphrase, a statement by a lawyer, so we don't know what exactly was said. And by the way, this is the lawyer relaying something here that Sarah told to him. Detective Copsall asked the defendant to sign a form releasing it to the sheriff's office for further investigation. Asked. Okay? The defendant acquiesced to authority and signed the form. Well, that's almost hysterical because the detective did not demand she sign a form. At least that's not what is alleged here. And can you see Sarah acquiescing? She's the queen. That day, she wasn't acquiescing to a whole lot. So it's not like she was this meek little mouse just giving authorities what they wanted. She was pretty demanding that they give her information. 9. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Well, you know what that tells me? That tells me they finished up at the apartment and she was allowed to go back inside. So it's not, they didn't drag her off. They didn't lock her out of her house. They could have if they needed to further investigate, but she was able to go back into her apartment, and it sounds like that was the plan originally. Most people wouldn't want to go back in that apartment, I don't think. Later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. So it sounds like Sarah actually stayed at the apartment by herself. She went in there. So she had access to the place. So that's, I think, an important little thing to know. And the fact that she was okay going in there, I don't know. Anyway, so she went to Brian's house. But she used her ex-husband's phone The defendant called the lead detective, Chelsea Copsall, to express her concern that Detective Copsall was not being truthful about law enforcement motives as it relates to the defendant. Oh, what was that? Edgar Allan Poe, Telltale Heart? Boom, boom, right? She knows. She knows and she's scared. The defendant told the detectives she believed that they were trying to trick her. Well, she's with Brian. They're not asking her for anything. It's over. But so this behavior was happening then. The detective assured the defendant that they were not trying to trick or manipulate her, but that the following day the defendant needed to drive to Orange County Sheriff's Office to retrieve her phone. The detective explained that the reason for the change in plans was because she was pregnant and not feeling well. Well, I don't know if that is the detective's reasoning or not. It could have been a pretext, and that's okay. The police can do that. And sometimes they'll get a defendant or a suspect into the station on a pretext because it's safer for everyone, including the defendant themselves. The next day, February 25th, 2020, the defendant arrived at the sheriff's office to retrieve her phone and had questions about this tragic event. Actually, her questions were not actually about the event. The questions were about who's contacting people, who's contacting the probation officer, and can I gave him a ring. Can I get that back? Where does that go? The questions were not. They were about her. They weren't questions about this tragic event. So, having walked in with a list of questions tells me that Sarah was not averse to conversing with the detectives. In fact, she wanted to speak with them. So, that goes to voluntariness. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. I do not know what the conversation was, and this isn't giving us any additional information. This is coming from the lawyer, but originally coming from Sarah. So we don't know. But if he did, big hairy deal. So Lowen leads her upstairs into the interrogation room. And the sentence here is a custodial interrogation ensued. Excuse me? At what point did they tell her that she was in custody, that she was not free to leave? At what point prior to that did they tell her she was in custody? They didn't. So at any point, she could have stood up and walked out the door. Now, voluntariness and those issues are a little more nuanced. It's not as black and white, and one could argue that the person perceived they were in custody, but I don't know that Sarah really did. You saw the videos, you saw the interrogation. So to say it's a custodial interrogation changes, it colors this entire thing, and it changes how a judge might think about it. So I hope the prosecution jumps on that and says it was not a custodial interrogation. Immediately after the interrogation, the defendant was arrested and charged with the offense above. This approximate 2-hour interrogation was recorded, and they go through this initial dialogue between Detective Copsall and the defendant. Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in, which tells me what? which tells me that it's voluntary. We didn't drag you in. You came in voluntarily. Sarah, yes, ma'am. And I want to ask about, oh my gosh, can you hear that in the background? I hope not. They've been running chainsaws since this morning outside. Sorry. Okay. Boone, I want to ask you about these whenever you have a moment, referring to her written notes with questions. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read your rights again because we have to talk about that. Okay. Again. I think that's key. So she's been read her rights and she still comes in and she's read her rights again. And the detective says, we have to talk about that. And the lawyer has this underlined. And I think the reason he has it underlined is because he's going to concentrate on the have to. We have to. Well, we don't know. We could mean we all. We could mean we police have to ask you about this. There are different ways to take that. And you saw Sarah's demeanor and you saw her responses. So she wasn't thinking, oh my gosh, I can't leave. She's giving no indication of that. And she understands. Detective, and we're not done talking about the incident. Detective, we just have to do it. And I think the defense is going to just jump all over on that and make it sound like there's no choice. But I would argue the detective is saying we, not you. You have to talk. Sarah, just like we did yesterday. Normal protocol. Detective, just like we did yesterday. Detective, remember I read you the rights. Detective, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? So they go through the rights, and one of the things that the detective asks is, has anyone threatened you or promised you anything to get you to talk to me? Answer, no. So he can't argue. They promised her the phone, and that's why she's talking to them. She just answered, no, there were no threats. There's no inducement. There's no promises made. Detective, and do you understand what I just read to you? Boone says, yes. Detective says, perfect, okay. And they start talking about the autopsy. The interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. The detective read the defendant her Miranda rights directly from the printed card. The detective omitted the final question printed on the standardized Miranda card of the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before. And the omitted final Miranda rights question is, having these rights in mind, do you wish to talk to us now? And they show an example of what they believe the Miranda card looks like. And so they're using this to say that this was coerced. Except the problem is Miranda doesn't say you have to have this card in your pocket and read this card word for word. The reason that they carry the card and the reason that they read from it is so that they don't inadvertently forget something or misspeak or say, phrase something the wrong way so that something is misconstrued. And then they can say, yeah, I read it off the card. Well, this last question here, having these rights in mind, you still wish to talk to us, is actually redundant. Okay? Because the first thing is that they have the right to remain silent. The first thing is basically telling her, you don't have to talk to us. And do you understand? The answer is yes. And you don't even need that question, do you understand? It's useful though. So I don't think this is going to go anywhere, but it makes me nervous that because what they're doing is they're going to chip away at this little thing, and they're going to chip away at that little thing, and they're going to gain some ground over here and chip away a little more over there until the prosecution just has threads left. That's the strategy, I think. Now, I'm going to check out the chat for a second. I have more documents for you, by the way, because there's something coming that just sinks the defense, in my opinion. All right, somebody says this motion is so dumb. I don't know. I don't think it should be granted, but I don't think it's dumb to try and push it out if I was on the defense side. Anyway, they're saying, as such, the entire 2-hour investigation should be suppressed. Well, I've been thinking about this. I knew this was coming. I've been thinking about this. And knowing how this can happen, where little by little they chip away, I was getting a bit nervous. Because if they could get rid of that, then the prosecution has less to work with. And the more they try and get rid of things, the less the prosecution has, the less of a slam dunk it is, and the more wiggle room the defense has to just say whatever Sarah wants them to say, basically. And as I was thinking about this and being worried, I realized some things. One is that Sarah can't shut her mouth. So at no time during all these letters did she talk about being afraid. She did mention unintentional, did she not, at some point? And there's still the 911 call. There's still the 911 call where she said, we were playing and I put him in the suitcase. We were having fun. We were playing. So that goes against any idea that she had to intentionally do this to him. And there's a whole lot of other arguments, about the whole thing, about all of it. There's so many arguments about him being in the suitcase and her not fleeing and not getting help and not acting afraid, all of that. So she said it to the 911 operator. She said it to the first responding officer. So they are going to have to get all of that suppressed somehow too. And then there is this supplementary discovery. And this is what sinks the defense. This, in my opinion, I think it's one of the things that sinks the defense's endeavors here in respect to this. And Sarah, thinking she's brilliant and talking to everybody, I mean, she did herself in early on. And that's not it. It's here. It is the statement of Abraham Moreno. The defendant was stating that, or sorry, this witness heard Boone saying that what happened was an accident on the day of the crime, and that the defendant said she was teaching him a lesson and things got out of hand and she fell asleep. And this witness recalls the defendant making this statement prior to law enforcement arriving on the scene. So that statement from Boone was in no way induced or forced, coerced at all by law enforcement. And the statement of teaching him a lesson is consistent with Sarah Boone's statement to the responding officer, which was, just leave him in there and make him squirm. And it's consistent with what we heard on the video that she took, saying, this is how it feels. This is for everything you've done to me. Aaron is saying, without the interrogation and Marino statement, Sarah, oh boy, I missed it. Okay. I'm sorry, Aaron. I will have to go back and read it later. And I would like to answer you now. Anyway, I don't think this defense is going to fly. I've never thought it was going to fly. I hadn't counted on the defense possibly getting rid of the interrogation recording. I don't think they're going to be able to, but if they did, there's still the 911 call. There's still this witness. The defense still has an uphill battle, and she's going to have to get on the stand. And the last document here is a notice of supplemental discovery, and the state is giving the defense body-worn camera videos from this earlier case. And I looked up what case that was, and that was the case where Sarah, and you've seen the video, where Sarah ended up getting charged because she strangled him. And having that come in, I mean, if the defense wants to play this game, well, then that kind of stuff is going to be able to come in. And that undermines what she's saying, as well as the video itself, right? So, Addie is sending me something. Addie. Addie, thank you. Addie sent me a super chat. I've been saving them all up. Watson, I know a lot of you have been asking me about Watson. So Watson's not feeling so hot. We're at the vet. It's going to be okay. I've been saving all my super chats and everything to buy a toy, like a really good quality toy for her. And I will make a video of her opening it, but that won't be today. Well, maybe this weekend. So thank you for that. So basically, I think they're really putting forth a vigorous effort here. I don't know that it's going to go anywhere. Now, I'm going to check out the chat here. Brad X says this is going to be such an SH show. Yeah. Even if they put Sarah on the stand, she can claim PTSD. Sarah is the gift that keeps giving to everyone but her own defense team, really. Super Kelly G says Marino was the maintenance guy at the apartments. Yeah, I think I have that interview somewhere on the playlist. Sriracha says this is going to be the best trial. I think Sarah will take the stand. She can't shut up. So, yeah, I think it's not going to go well. Oh, somebody was asking me too if she takes the stand and because the defense can't suborn perjury, maybe she will give a narrative and whether or not she can be cross examined on that. And the answer is yes. Yes, she can. Frocky says, I think that was a condition Brian set for letting Sarah stay with him and the son. Sarah doesn't seem like she cares about what her kid has to go through. Yeah, she really is all about her, isn't she? Okay. Are there questions? Joe says, seriously considering the start date for my new job in October. That's hilarious. Grayfish, this motion is almost exactly what was argued during the last hearing, and Kranick was definitely leaning towards no. They didn't officially argue that motion. They discussed it, I think, more than arguing. And what they were arguing over was whether or not the state had to provide the defense with this Miranda card and the sheriff's office's procedures. Well, and that was the issue. The defense is wanting the prosecution to run around and do their work for them, and the judge is saying basically what we've talked about before is that's their policy. I mean, the issue on voluntariness is it's related to the Constitution, not a policy. So it doesn't really matter. AKA the cat lady says there's no case is here either. I think it won't fly. I think they got to do everything they can. You don't want Sarah coming out later saying, I told them to get that thrown out and they wouldn't even try. Could you see her saying that? Liverbird 1984 says 100% she should have stuck with accident and being blackout drunk. Being blackout drunk is not a defense. Having a blackout means you can't remember. It doesn't mean you didn't do it, and it doesn't mean that you weren't capable at the time of the crime to form the intent to do it. And if you don't remember, well, how do you defend yourself then? If you don't remember, well, anybody could say anything, and you have no defense because you don't remember. So that doesn't work out well. Brat says, I can't imagine not pleading to this. I think there's a thing in her that even if they gave her a great deal, I think that just psychologically she cannot handle taking responsibility. Do you think she requested makeup by Mario yet? Somebody's saying. I don't know. Ginger Snap said if she had been honest and shown remorse, she may have received lesser charges. Yeah, I don't know about that. I don't know about that. Especially considering the recording where she's saying F you. Right? It's pretty bad. So I think that's it. So Sarah, the bottom line, Sarah's benefiting from the work of many, many lawyers. And the saga goes on, and her own words and her own behavior, it sounds like with this one witness, she was trying to get out ahead of it. With her own words, she sinks herself. You see, this is why they tell you have a right to remain silent. And there are some lawyers who will say, exercise your right to remain silent. Shut the F up, they'll say. Really. Don't even tell them what you had for dinner, because often that's how the conversation starts. At least up here, police will say, "Hey, so what do you think? What do you think of the Blue Jays? Or what do you think of this hockey team that played last night?" And you get going in a conversation. And before you know it, you've told the detective your whole life story. And you're best buds. And they get confessions. Marianne says she has no conscience. Yeah, gotta wonder. Kathy, she's counting on a mistrial and time served. I don't know. Do you think it's possible, somebody's asking me, do you think it's possible she fires Mr. Owens before trial? Anything's possible. I don't think she's gonna at this point. I think, though, if she loses, she is going to write letters and say how evil everybody was. I think she'll do that. She will. Everything has to be everybody else's fault. Nothing is her. So Robin is saying hard to keep your mouth shut once the video came out. Yeah. I don't know how you get around that. Helen B., she still thinks she's not guilty. I think in a way, in a certain way, I think she honestly believes it. I think she believes that, well, because I didn't have premeditated in my mind, like I didn't have this big plan, and this happened, therefore I'm not guilty because that wasn't my intention. Except she's, failing to take responsibility. How many of you have ever had a situation in life where something has gone wrong and maybe somebody else got hurt because of a mistake you made? It doesn't have to be serious, but even a dumb thing. And how guilty you feel. Oh, even if it wasn't your fault, you think, maybe if I would have done this, then this wouldn't have happened and that person wouldn't have suffered. I'm not sure if I'm making sense there. But Sarah has gaslit herself, Sub Rosa says. Yeah, I think so. Somebody says they think that Sarah will refuse to attend. Oh, I can't imagine. Do you think there's any chance they'll get the interrogation thrown out? I think it would take some mental gymnastics. I'm not a lawyer in Florida. Okay, I'm up here in Canada. I don't see it. But I have seen cases on voluntariness where the nuances matter. And so when they do interrogations, at least up here, they're very specific, very conscious about where everybody's sitting. And part of that is because you want to make your subject feel a certain way. They use kinetics and all kinds of stuff. You want to make your subject feel a certain way, but at the same time, it's all being recorded, and you want to be able to show a court that you weren't physically intimidating, you didn't physically block the door. There are a lot of things that can make a person believe that they're at risk and they will therefore comply where they ordinarily wouldn't. So a lot of things get debated. One of the things that is taken into account is, what a reasonable person believes, and they'll look at her behavior. She's coming in with a list of questions. I think at the time I saw it, I said, what is she going to do? Like pull out, ask them to go pick up her dry cleaning? or something next, like the way she was so demanding. So it wasn't like she was this little mouse afraid of them and just complying with authority. I mean, the use of this language in here, I understand what they're doing, but they're not dealing with the jury. They're not dealing with just average Jane Doe or Joe Blow. They're dealing with this judge. I mean, this judge has a brain in his head. Suraj, she can't even consider how she has taken away a father, a brother, a son. Yeah. And that is the other thing. So much focus has been put on Sarah and Sarah's rights and how Sarah is and what Sarah should have. And maybe they should give her this and maybe they should do that for her. What about Mr. Torres's family? What about his kids? What about his mom? I cannot imagine what these poor parents went through. And it does not matter. No, he wasn't an angel and all that, because nobody is. What grief. And to have that video out there. I mean, that's one of the reasons why I wouldn't play it on my channel. Imagine being a family member and having to see that. Much endeavors. She's famous in demanding a hair and makeup person. I mean, seriously? They can ask to a reasonable extent to, be made presentable, but the way just the way it came across, I don't know. I wish, I was going to say, I wish I had somebody to do my hair and makeup, but I actually probably don't care that much. So she cares for no one but herself. Someone saying yes. Frocky says, George was a friend to her son too. Yes. Yes, he was. They were seen riding bikes together. Aaron says, Sarah pleading it was an accident isn't about getting her acquitted or found not guilty. It's trying to get the court to show mercy on her come sentencing. Yeah, except now they don't want to call it an accident. Now she has to say that she intentionally took actions and because of battered spouse syndrome. Ginger snaps, wait until she asks for a spa day and a personal trainer. She really does seem entitled. Karen G, I feel for his family too. Yana brings up a good point. She says it's weird to request street clothes and makeup for a hearing for a hearing that is not in front of the jury. She wanted that for the hearings, not just the trial. And I think that's a good point that you bring up, because what is that about? That's about how she feels, and that's about how she's perceived on camera. This isn't about presenting in front of a jury in a certain way. And Jane says, yeah, funny, watching all her videos, she wore stinky pants and t-shirts. Yeah, she was a mess the rest of the time. But, when you go on TV, maybe you want your hair done. Sriracha, she has made a very bad decision because there are a ton of videos that show she was abusive too. Yes. Yes. Ginger Snaps thinks the flip-flopping will work for the prosecution. Helen B. Helen B is asking why was it granted, and I must have missed something. This is a motion that it has not been heard in front of the court yet. So this motion to suppress is something the defense wants. The judge is going to have to hear it to see. Captain KD says Owens told her, I take your case, we do it my way. So she can try to play her games, but it will be at her own expense. Yeah, maybe. I think Owens is a very strong personality. I think he there are lawyers who will be very personable and very nice, and that's how they get the client to sort of go along. And others will be, listen, pal. And they don't use the word pal, okay? And they lay down the law, and it'll be an F you, then you're on your own if you don't do it my way. And she knows now what it's like to not be represented and stand there in court. Brian better not go up there and lie because he doesn't think he was abused because he's a big guy and she's a tiny woman. I don't know that he would do that. I think that's an important issue, though, that she went after him as well, physically. Jules says, yeah, in Brian's body cam interview, he seemed pretty forthcoming about that. Yeah, he said she was violent with him before she met George. TT says it's about control for Sarah. Yeah, totally. And Kimberly is asking, didn't Sarah Boone during the interview ask them continuously to just look at her phone to see what's on there? Yes, she did, repeatedly. Okay, so it is 5:47 p.m. I think I'm going back. Not malicious. I think I'm going to end the stream. There's a meeting I have to go to. I thank you for so many of you joining me on this sort of impromptu live stream. So many things happened today that were unexpected. And yeah, and I think they're coming back tomorrow to cut down trees next door. Oh, it's crazy. Oh, what do you think about Mr. Owens? I don't like him. Yeah, I think I am going to, you know what I'm going to say, Jane? I'm going to say I've read some material. I've seen him work in Sarah Boone's case. And yeah, I think, you know what? I think I'm going to refrain from personal and what I think about him personally. I think it doesn't matter what I think. I do have a bad feeling. I think there's something more going on here than what meets the eye, but I do not, that is just my opinion, and I do not have evidence, so I can't say more than that. Okay? So thank you, everybody, and I will see you actually in a couple of days, I guess, because they're having the hearing on the 26th or the 27th. Anyway, I'm going to try and live stream that. I've made some changes to hardware, so hopefully there won't be lagging, and I will talk to you then. Trust your gut.